This is an overview of the judicial lien avoidance process under Section 522F of the Bankruptcy Code and some common issues that arise in the adjudication of these motions. This overview is provided for informational and educational purposes only. It is not intended to be legal advice and does not represent the position of any particular court or judge. Judicial liens are created when a party sues an individual, usually through a civil complaint in state court, and as a result of that proceeding, obtains a money judgment on property that the debtor currently owns or property that the debtor will acquire in the future. In this video, we will go over judicial lien creation, judicial lien search, bankruptcy schedules, the judicial lien avoidance formula, when and how to determine the amount of liens, priority of liens vis-a-vis the lien to be avoided, order of judicial lien avoidance, the exemption, the value of the property, concurrent ownership issues, the fixing of the judicial lien, timing of a motion to avoid a judicial lien, and avoiding judicial liens held by creditors with non-dischargeable debts. This is an example of a recorded judgment. It bears the date the judgment was recorded and the book and page number of the judgment book. A copy of this document should be attached to the motion in bankruptcy court to avoid the judicial lien. We will now hear from the Honorable Judge David Bissett from the Northern District of West Virginia.
Regarding an attorney's due diligence in determining whether a judicial lien is in existence, note Judge Kidding's decision in the Northern District of Ohio in the case of In re Horvath, where he noted the importance of an attorney's preparation for due diligence, including lien searches, cannot be understated. Per Bankruptcy Rule 9011B, a petition presented to the court certifies the representation contained therein are presented to be the best of the person's knowledge, information, and belief formed after an inquiry, reasonable under the circumstances. Failure to adhere to this duty may open counsel to sanctions.
Attorney Kelly Coder explains the process for judicial lien searches before a bankruptcy case is filed.
The good thing about searching for liens, now is that it's very easy to do online. Most of the courts, at least in the counties around here, have online access, so it's very easy to pull it up to check to see if there are judgment liens filed against our potential clients. There are a few counties, however, that do not have online access, so in those cases, you have the option of sometimes you can call, and if you get someone who is helpful, they will look them up for you, or in the alternative, either I will have to go to the courthouse or I'll have my client go and check in person.
We will now hear about a recent case where a judicial lien became a matter of great importance.
It involved a debtor who had filed bankruptcy several years ago and did not strip off their judgment liens while the bankruptcy was open. And they had filed a motion to reopen their case to avoid the judgment liens. And the judge actually ended up denying the motion and said that it was something that should have been addressed while the case was open, and kind of insinuated that it could be legal malpractice if attorneys are not proactively checking to make sure there are judgment liens and addressing them while the bankruptcy is open. So even though that case isn't binding precedent, I have taken even more steps in my office to make sure we seek to find if there are judgment liens so we can address them when the bankruptcy is open.
In evaluating whether the judicial lien shown previously is avoidable in a bankruptcy case under Section 522F, let's look more at the bankruptcy schedule in that case. The bankruptcy case was a joint petition filed by a married couple. The judgment is only against the husband, but both own real property together and are both liable on consensually secured debts against the property. On Schedule AB, the debtors listed real property located in Ohio County, West Virginia, having a value of $161,000. Then, on Schedule D, the debtors listed the debt secured by this property. As shown, the debtors have a first mortgage in the amount of $107,445 and a second mortgage in the amount of $27,997 for a total amount of $135,442 in secured debt. Both debtors are liable on the debt. Generally, this means that each debtor is liable to repay the mortgage. For example, if one spouse died, the entirety of the mortgage obligations would be owned by the remaining party on the note securing the deed of trust. Because the property has a scheduled value of $161,000, this means that the debtors have the equity in the property in the total amount of $25,558. On Schedule C, the debtors have this case claimed as an exemption and the property in the exact amount of $25,558, meaning that there is no non-exempt equity to distribute to creditors. With regard to the judgment lien in favor of Discovery Bank, the attorney in this bankruptcy case chose to list it as an unsecured debt on Schedule EF. We will now hear from Attorney Mike Claggett on scheduling a judicial lien on Schedule D or on Schedule EF.
Well, if you know a debt is a secured debt, you'd want to put it on Schedule D. If you didn't know it was a secured debt, or it wasn't a secured debt, it would be on EF. Actually, of course, the F part, the original unsecured debt. But it really doesn't make any difference. The debt's either secured or it's not secured. Just because you put it on Schedule EF doesn't change the secured nature of the debt. Oftentimes we don't even look for the judicial liens until after we've already filed the case. So oftentimes it will appear on Schedule EF, but of course obviously we discovered it was a judicial lien. And of course there's some liens, some judgments that are recorded, but they don't stick in anything anyhow, so technically those are unsecured debts anyhow. We try to be as accurate as possible just to make it all look nice and pretty on the petition, but it's really in the long run doesn't make any difference anyhow.
Okay, now that we have the pertinent information from the debtors' schedules, let's look at the judicial lien avoidance motion. The requirements for avoiding a judicial lien are stated in Section 522F of the Bankruptcy Code. First, it is the fixing of the judicial lien that is being avoided. This generally means that the judgment debtor has real property to which the judgment lien has attached under state law. At that time, the judicial lien is fixed to the property. Second, the judicial lien must impair property in which the debtor has an interest. Third, the judicial lien must impair an exemption to which the debtor would have been entitled. Note that the language of the sentence is hypothetical. Fourth, the lien must be a judicial lien, not a consensual lien or a statutory lien. Fifth, a judicial lien may only be avoided to the extent that the judicial lien, all other liens on the property, and the amount of the exemption that the debtor could have taken in the absence of a judicial lien exceeds the value of the property. The Bankruptcy Court has deciphered this mathematical formula for individual debtors and has a judicial lien avoidance formula available on its website. First, let's add all the liens together. This includes any consensual liens, statutory liens such as tax liens, and all judicial liens. Next, determine the exemption that could be claimed in the property in the absence of any of the liens. Remember that in this case, the debtors listed an exemption in the amount of $25,558 on Schedule C, and even though the exemption amount used in the formula is hypothetical, attorneys often use the actual exemption claimed on Schedule C in the judicial lien avoidance motion, at least when the actual exemption will not change the outcome of the motion. Now that we have an understanding of how the judicial lien avoidance formula works, let's look at more specific examples that can arise in litigation.
When to determine the amount of secured debt against the property? The easy answer, the simple answer, is that it is the petition date. The petition date is when we determine the exemption that the debtor would be entitled to. The petition date is when we determine the value of the property. And so there's concordance between these three elements of the judicial lien avoidance formula: value, exemption, and the amount of the liens. However, as often happens, the motion to avoid judicial lien may not be filed until months or even years after the petition date. And in the meantime, perhaps the debtor has been making secure debt payments, reducing the amount of secured debt against the property, which in the formula works to the advantage of the judicial lien creditor, or the opposite could have occurred. The debtor is not making the secured debt payments, increasing the amount of the consensual liens against the property to the detriment of the judicial lien creditor. However, on this point, courts have been pretty clear. It is the petition date that governs.
Unlike a consensual mortgage that is associated with regular debt service statements detailing the amount owed on a recurring basis, a judicial lien, under state law, is associated with a statutory interest rate. Often, the applicable interest rate is stated on the abstract of judgment. Post-judgment interest in West Virginia state courts is governed by West Virginia Code Section 56631C, and with some limitations, it is 2 percentage points above the 5th Federal Reserve District secondary discount rate in effect on January 2nd of the year in which the judgment or decree is entered. If a person is unsure of the judgment rate in effect at the time of entry of judgment, the West Virginia Supreme Court of Appeals maintains this information. However, in the judicial lien avoidance formula, adding interest to the judgment from the date of its entry is not a necessary step to filing the judgment lien avoidance motion, because it has no effect on whether the judgment may be wholly or partially avoidable under the formula. Look at this example. In this case, the judgment was obtained on December 19, 2019, in the principal amount of $7,750.88. According to the Supreme Court of Appeals for West Virginia, the 2019 judgment interest rate was 5.5%. Thus, if this debtor had filed bankruptcy on December 19, 2020, the amount of the judgment would be approximately $8,177.18, but the net effect of the judicial lien avoidance formula is unchanged. Let us now turn to the next requirement in the judicial lien avoidance formula, which focuses on all other liens against the property.
Okay, let's talk about the priority of liens in the judicial lien avoidance formula. Outside of bankruptcy, the rule is the first to record a secured debt or any debt against property has first priority, the second to record has second priority, and the third to record has third priority in payment. Therefore, when property is sold, the first proceeds go to the senior debt holder. Any proceeds left over go to the second priority debt holder. Any proceeds left over go to the third priority debt holder. And if there are any further proceeds, those are payable to the debtor. Now let's look at what happens in the judicial lien avoidance formula by looking at a specific case. Now here the debtor incurred a $219,000 first priority senior mortgage. Then the debtor was engaged in litigation, which resulted in a judgment in the amount of $134,000. That judgment lien was recorded, meaning outside of bankruptcy, the judgment lien creditor had a second priority position in terms of any payment that might result from the sale of the property. Now, before filing bankruptcy, the debtor incurred another consensual secured mortgage in the amount of $80,000. Now, after the debtor filed bankruptcy, the debtor attempted to avoid the creditor's judicial lien by adding both the first priority consensual lien and the third priority consensual lien to the amount of the judicial lien to be avoided. And as you might imagine, the judicial lien creditor objected, arguing that only the priority debt to the judicial lien to be avoided could be used in the judicial lien avoidance formula. Now, the statute itself is silent on this point. It only says all liens, be it a senior priority lien, a junior priority lien, a statutory lien, a mechanics lien, or other judicial lien. All liens are added together in the formula. And in looking at this language and in not seeing an exception for only priority liens vis-a-vis the judicial lien to be avoided, the Eighth Circuit allowed the debtor's argument to prevail. So, in this case, when engaging in pre-bankruptcy planning, there is an avenue for a debtor to manipulate the judicial lien avoidance formula to reap an advantage. However, look at what the Eighth Circuit Court of Appeals said. We are not entirely comfortable with the equities of literally applying the statutory formula in this situation. It may give a debtor contemplating bankruptcy the ability to wipe out judicial liens by persuading a lender to take an otherwise junior consensual lien that renders the exempt property over-encumbered and therefore ripe for impairment. There may be times when self-interest or hard-to-detect collusion will lead to an abuse of Section 522F. On the other hand, refusing to apply the statutory formula as written may result in denying deserving debtors the fresh start advantages Section 522F was enacted to provide. So, in contemplating bankruptcy and engaging in pre-bankruptcy planning, keep in mind this admonition by the Eighth Circuit Court of Appeals. What may be abusive or what may be appropriate under the circumstances is not something that I feel comfortable explaining. Perhaps that's why we have bankruptcy judges. Now, on the other hand, when addressing multiple judicial liens, the statute is also silent as to which judicial lien may be avoided first under the formula. And in general, property and interest in property are determined by state law. And under West Virginia law, the judicial lien creditor who is first to record has priority in payment. So using this as a general guide, the Bankruptcy Court for the Northern District of West Virginia, in an unpublished order, has determined that the junior judicial lien is the first to be avoided.
For the judicial lien avoidance formula to work, the judicial lien must impair an exemption to which the debtor would have been entitled if there were no liens on the property. Federal exemptions are listed in Section 522B of the Bankruptcy Code. As of July 2021, those federal exemptions are available to West Virginia residents, or a West Virginia resident may choose the West Virginia bankruptcy exemptions, which are found in West Virginia Code Section 3810-4. At the time of this video, Section 3810-4A provides a homestead exemption of $35,000 for a single debtor or $70,000 for joint debtors that both have an interest in the property. Also, Section 3810-4E allows a wild card exemption in any property of $800. The statutory formula of judicial lien avoidance asks that the amount of the applicable exemption be determined as if there were no liens on the property. This means the amount of the exemption is calculated without regard to existing consensual liens, statutory liens, or judicial liens. Because the exemption amount is hypothetical, it does not need to be actually claimed on Schedule C. The debtor's claims of exemption that accompany the bankruptcy petition, but it may nonetheless be a good practice to claim an exemption in a nominal amount even when the property is fully encumbered by consensual liens, and to provide consistency between the exemption claimed on Schedule C and the hypothetical exemption listed on the judicial lien avoidance motion. Briefly, there are 4 other issues regarding exemptions that arise infrequently.
The first is the exemption by declaration. When a debtor files a bankruptcy petition, the debtor has a certain period of time to make a declaration of exemption, and once made, other parties in the case have a certain period of time to object to that declaration. Now, as a result of a case from the United States Supreme Court, if no party makes a timely objection to a wrongfully claimed exemption, the debtor is entitled to the exemption claimed. So, in the judicial lien avoidance formula, when we talk about a hypothetical exemption, the argument is this. I could claim a hypothetical exemption in the property. So, for instance, if the state law homestead exemption were $35,000, I hypothetically could declare an exemption of $100,000 or $1 million or $10 million, it really doesn't matter, and use that in the judicial lien avoidance formula. To date, I've never seen that argument made, and if it was made, it is highly unlikely that it would be successful. In general, the hypothetical exemption that a debtor is entitled to is the exemption provided for by statute, either federal or state. The second issue that sometimes arises is this issue of the lost exemption, and this is how it arises. As of the petition date, the debtor owns real property in which they claim a homestead exemption. The case is closed, the debtor gets their discharge, and everybody moves on with their life. Several years later, perhaps, the debtor seeks to sell that property. The property is sold, the money comes to the dispersing agent, the closing agent. And that's when this pre-bankruptcy judicial lien is discovered. So the debtor runs back to bankruptcy court, reopens their bankruptcy case, files a motion to avoid the judicial lien under 522F. Now, the judgment lien creditor makes the argument that, wait, the debtor is seeking to use a homestead exemption under the formula. The debtor no longer owns the property. The debtor has lost the right to declare a homestead exemption and lost the right to use the 522F formula. When this issue came before the Court of Appeals for the Ninth Circuit, the court plainly stated that it is the petition date that matters. What happens subsequently is really irrelevant. The third issue that occasionally arises deals with amended exemptions and whether or not the amendment relates back to the time of the petition. The federal exemptions, for example, are amended every 3 years in line with the Consumer Price Index. Just before this video was made, the West Virginia homestead exemption was increased. Generally speaking, however, we are looking at the petition date. And the fourth issue that arises, and this is unique to West Virginia, isn't really an exemption issue at all. Let me explain. As a result of this court case from the Supreme Court of Appeals of West Virginia, a husband and a wife owned real property. The husband had a debt that was reduced to judgment, and the judgment lien creditor sought to sell the jointly owned property to satisfy the judgment lien debt. The Court of Appeals for West Virginia said, not so fast. We're not going to allow a judgment lien creditor to sell jointly owned property when it's to the detriment of an innocent spouse. So as you see, it doesn't really deal with exemptions at all. It deals with a prohibition to the sale of real property under very certain circumstances.
In the judicial lien avoidance formula, the value of the property subject to the judicial lien is of critical importance. As a rule of thumb, the bankruptcy debtor benefits when the value of the lien is high in comparison to the price of the property. The creditor benefits from the exact opposite situation. Let's look briefly at how the price of a property affects the lien avoidance formula. In the example, a $10,000 difference in the value of the property is the difference between whether the judicial lien can be avoided or not avoided. Let's ask an attorney for a bankruptcy debtor and an attorney for a judicial lien creditor how they generally approach valuation issues in lien avoidance motions and how they establish value at an evidentiary hearing. We will now hear from bankruptcy attorney and Chapter 7 trustee Aaron Amore.
My name is Aaron Amore, and I've been asked to talk about motions to avoid judgment liens, specifically how a debtor assesses the value of the property upon which they are going to ask the court to avoid a judgment lien by a creditor. The provisions of the Bankruptcy Code are fairly straightforward with respect to the debtor's use of exemptions. With respect to the valuation, it's really a fair market value as of the date of the filing of the petition, or with respect to the property that becomes property of the estate. In some cases, the debtor inherit property while they're in a bankruptcy, or they may own it beforehand. So the determination really is as the date of filing a petition or when it comes into as property of the estate. Obviously, most of the times we're looking at debtors who are trying to exempt their personal residence. It may be a lot related that's subject to an exemption. Rarely are we looking at kind of an analysis that would be like a highest and best use analysis like you would for a commercial property that we often see in Chapter 11 cases. So really what the debtor is looking to do is to say, how much exemption do I have with respect to this specific property, and how do we look at the judgment lien in relation to the value of the property. The debtor can testify as to the value of the property, whereas a creditor would have to hire an outside expert if it wanted to object. So a debtor's competency to testify as to the value is kind of a critical component, and oftentimes in motions to avoid judgment liens, these go uncontested. Where there is an objection, obviously there's a dispute, usually between a creditor who might be intimately involved to the extent that the debtor may be a divorce proceeding, or a creditor has a specific loan for, let's say, a water softener or the like. So in looking at valuation sources, I always say that the debtor is an incredible source of information, at least for the attorney, both to assess the quality of that valuation and the kind of competency of their client as a potential witness. Obviously, inquiries of the debtor are critical to the extent of when did they buy the home, how much did they pay for it, was there a down payment, did mom or dad give them some money to put down on the property, were there any substantial repairs done on the property, were there any substantial problems with the property. Hey, we bought this property, moved in, and it's got a pool, but the pump's gone and we've got to get it torn out, or the roof is leaking. So there could be a whole range of information and factors that lay into a valuation assessment that's important to get from the debtors themselves. Whether or not there are outbuildings, garages have been added, fixtures, those all increase the value of the property. Also with respect to the debtor's debt on the property, has there been a recent refinance? Obviously, in any type of refi of a debt, the creditor is going to look to do a valuation, whether it's a BPO, broker price opinion, or an appraisal. That information is usually available, with respect to getting some good assessment as to at least what a creditor might value that at. And again, we know that oftentimes refinances are 70 to 80% per value. So in assessing what the value of the property is, that's a good way to look. Because of the debtor's familiarity with the property and understanding the expenses necessary to maybe bring a house up to 100% value, that's kind of an important component. The things that I will normally do, in addition to gathering the information from the debtor, I'm going to look at the deed. In West Virginia, the deed requires to state the consideration. Oftentimes that consideration is not exactly what a debtor is paid for it. So you want to maybe confirm with respect to the deed consideration and the deed of trust. And then with the debtors, oftentimes through closing documents, where there's any question as to that, to confirm what consideration was paid. Oftentimes, if it's a recent sale, if it's a fair market, third-party transaction, that consideration is usually pretty good value. Are they buying it from mom and dad or some family member, or did they get some sort of deal from an ex-spouse in divorce? Those are all components to look at when you're looking at kind of what are the deeds and deeds of trust saying with respect to the value. Another good source are appraisals. Obviously, most people are financing their property, they're going to get an appraisal. The problem with appraisals by and large is normally between 1.5 to 2 years, those appraisals are stale. They're no longer good because the market conditions have changed. The other thing I'm always dubious about appraisals, because it can look at square footage, it can look at location, it can look at how many floors and how many outbuildings there may be, but it doesn't tell you anything about the quality of the property. It could need a new roof, it could be riddled with termites, it could be in premier shape, or it could be in poor shape. There's no assessment when an appraisal is done. They're simply looking at square footage, location, and the comparables of houses that are in a like circumstance. So the appraisals can often be misleading with respect to the value, given the age and location of the house. Tax records are often kind of overlooked, important sources of figuring out, at least what the value of the property is. Obviously, fair market value considerations are what a willing buyer is going to pay. right? So the market conditions are going to dictate exactly what those are. To the extent that you have a recent sale, third-party transaction, you probably take that to the bank. That's a good value. You probably have comparable home sales. But if you have someone who's owned the property for 20 years, the market is taken off around them. Maybe they're in a good neighborhood, maybe they're in not such a good neighborhood that's developed, maybe it's commercial. So oftentimes you're stuck with, maybe debtors, maybe they're older, who don't really have a good sense of the value of their house. Looking at the tax ticket and the tax records does not give you a good sense of the true value. Basically go to the sheriff's office. So when you go to the sheriff's tax office, essentially you get a screen like this. Here and I can look and I can say, what this real property is and what it's assessed at. So we look at what the tax assessment of this property is. The other thing you can do with respect to the land records is, you can look up first name, last name, you can search by property so that you can see the deeds, the assignments, the deeds of trust. You can look at all these records to make sure that you have good information about what's going on. The other thing you need to be aware of, obviously, with tax records is normally assumed tax levy rates for residential property are around 60%. Every county is a little bit different. Every 2 years they set what's called the levy rate. The levy rate in Jefferson County is about 58% per value. So when someone comes in, and I get this all the time when debtors testify at 341 hearings, you ask them the value, it says it's appraised at X. And then when you finally get them, they say, well, it was assessed by the assessor's office at X. And of course, that's only about 60% of the value of the property. You would then calculate that property to see what 100% of that value is. So oftentimes, those are really good opportunities to take a look at kind of what's been done with respect to the rates. Obviously, commercial rates are also different when you're dealing with Class 2 properties, and industrial rates are different. Most debtors aren't in a situation where they own industrial property or commercial property, but they may have some excess land that they want to exempt or some farmland. So that comes into play. In addition, one of the most critical, at least I think critical, assessments is the application of Zillow, Redfin, Realtor.com. So if you want to search, any property that you want, you can go to Zillow and you can say, hey, I want to search a property. Actually, let me do that. And it's going to tell me a whole bunch of information. It'll also show when it was last on the market and what it sold for, cost of sale, and then comparables. You have to be very careful about knowing what it is that you're valuing and what the values are. So those are generally the kind of resources that I use. When all else fails, and I get someone who has absolutely no idea as to what the value of their property is, and I can't get a good assessment from Zillow or one of the resources, I will call a realtor friend of mine, and I have other debtors attorneys who do this. Realtors are happy to pull comparables anymore because they log into MLS and they put in the address and they can pull up 3 or 4 comparable properties. They can print what's called a CMA for the comparable and provide that to the debtor's attorney. And in cases where there might be a question or not accurate information, the realtor is going to use the MLS database, which pulls the entire region in to say, hey, this property, and then look at these comparable houses. And oftentimes, if I have a motion to avoid a judgment lien, and there is some dispute over the value, I will attach to the motion the CMA from a realtor. I will attach documents that I feel are necessary to establish the motion. And of course, the last thing that I do normally is, if there is work to be done, I have comparable on a house, and maybe it's $200,000, yet there might be $20,000 or $30,000 work to be done. I have the debtor go out and they get written estimates from West Virginia contractors, licensed contractors, to say HVAC system is failing, it needs to be replaced, it's going to be $8,000. We need a new roof, the deck's falling off, it's going to be $8,000. So that when we're looking at what is the value of this property. It's just not a static value of the property, but a value of the property of, hey, these repairs need to be done in order to maximize the value which appears on, either Zillow or some comparable. So that's normally what I do. The more information that you can glean and provide, I always say, kind of scares off creditors from objecting, because when the creditor objects, obviously they have to file an appearance. Normally they're going to have to hire an attorney. They're going to have to hire either an appraiser or some type of expert to come in to provide kind of countervailing evidence to show that the property is worth more. And oftentimes at the end of the day, you're really negotiating on the fringes of what you're looking for. The debtor's exemption, oftentimes if it's close, you're looking at a situation where some or all of that judgment may be exempt. Obviously, the debtor exemption for residential real property here is going up in July, I think on the 14th to $35,000. So it's a situation where that exemption is going up, but again, values are going up, especially in Jefferson County, the Eastern Panhandle. So it's often a bit of a sticky wicket to the extent that as the values go up, the judgment liens for those people who've owned properties, right, who maybe not have paid down as much debt but have owned them for several years, have seen the market go up. So it's important, especially when talking to debtors about filing bankruptcy in the first place, to see, does it make sense for them to do that? Is there any risk of loss of an asset before you even get to that judgment lien avoidance?
We will now hear from bankruptcy attorney James Lane speaking on the creditor's perspective.
In most of the cases that I can recall dealing with lien avoidance, it involves real estate. And so we're talking about the value of real estate. And from a creditor's perspective, it's probably largely is the same as from a debtor's perspective, and that is the best way to establish value is to hire an appraiser to go out and inspect the property, and it becomes a battle of your expert against the debtor's expert in court, and that just seems to be where you are. It's not. I don't see a difference in valuing it from either perspective. The value should be what it is, whether you're a creditor or a debtor. You just want a reliable expert to evaluate the case and tell your client, and hopefully tell the court with some authority what you feel the value is. In a case that I had lately, the debtor placed a low value on its schedules, and that did not seem to be accurate. And so we looked back at the loan application process and what the debtors, when they were applying for the loan, what they put a value on the property at that point, which may have been a more candid assessment of what the value was, because they weren't in jeopardy of losing equity in their property at the time if it was a high value, or winning the case if it's a low value. It's more honest, you would think. And in that case, they put a much higher value on their house. And in addition to our appraisal report, we intended to ask the debtor some difficult questions about why they represented to the creditor when they were getting a loan that the value was high, much higher than what they put on their schedules. And we hope to gain some points with the judge in that, using that argument as well.
As shown in our first judicial lien avoidance example, sometimes a judicial lien exists that is effective against only one of two filing spouses who jointly own real property. When this situation arises, application of the judicial lien avoidance formula can be complicated.
We are going to look at 4 different approaches to applying the 522F formula in this specific situation. And the case law in this area, at least from my perspective, is a little bit confused. But before we get there, let's take a step backwards and look at a form of ownership called tenants in common, and what happens when one tenant in common files bankruptcy. For example, in the case of Henry Pearsall, a brother was a joint tenant in property with his sisters. And let's say the brother owned 30% of the property. When the brother filed bankruptcy, he attempted to avoid the judicial lien held by a creditor. And when he applied the formula, he used a valuation of the real property that was 30% of the entire value to reflect his ownership interest. And the creditor, however, objected to this valuation and said, under the formula, you need to use the full value of the property. The court, however, disagreed and said because the brother only owned 30%, he had no right, title, or interest in the other 70%. The correct valuation for the judicial lien avoidance formula was 30%. Okay, one more preliminary point. Let's look at what happens to a joint tenancy. A joint tenancy is where 2 people own 100% of the property, as Mitchie's jurisprudence of West Virginia and Virginia states.
One of them does not have season of one half and the other of the remaining half. Neither can one be exclusively seized of 1 acre and his companion of another. Each has an undivided moiety of the whole. From this, it follows that the possession and season of one joint tenant is the possession and season of the other.
So let's look at what happens by examining 3 different cases. The first comes from a case from Colorado in 1983. There, the bankruptcy court held that when a married couple files bankruptcy and holds property as joint tenants, the filing of the petition severs the joint tenancy and the husband and wife become tenants in common. However, this case hasn't seen a lot of traction over the years, and in fact, in 1990, there is a published decision from this district, the Northern District of West Virginia, that holds exactly the opposite. There, 2 people owned a bank account by joint tenancy, and when one died, the other claimed the entire amount of the bank account. A creditor argued that the death or the bankruptcy petition severed the joint tenancy. However, the court disagreed and found that the filing of a bankruptcy petition had no effect on the right and title of the party's interest in the bank account. It remained a joint tenancy. And also, there is an opinion from 2000 from the Court of Appeals for the Fourth Circuit, Greenblatt. And it held that the filing of a bankruptcy petition does not sever a tenancy by the entirety, which is a form of joint tenancy not recognized specifically in West Virginia. So, based on these 2 cases from this district and from the Fourth Circuit, we will just assume that the filing of the bankruptcy petition does not sever a joint tenancy. Okay. Let's look at the first application of the judicial lien formula in this very specific situation. Jointly owned property, judgment lien against one of the 2 spouses. And this case is Henry Kozat from the Bankruptcy Appellate Panel from the 10th Circuit from 1997. And if we look at how they applied the formula, you will see there is a discrepancy in value. Okay, so the debtor said, we are going to use 100% of the liens on the property. Now remember that, unless it's a very unusual case, when spouses sign a mortgage note, they are signing as jointly and severally liable partners, which means that each spouse is 100% liable for repayment of the note in full. It's not the case that the husband only has to pay 50% and the wife has to pay the other 50%. No, they are both 100% responsible to the lender. And so in this case, the debtor used 100% of the value of the liens against the property, but he said, when it got to value, that as a joint tenant, I presumably only own 50% of the property, even though I have a right to occupy the whole 100% of the property and enjoy it as my own. We have to recognize the reality that this is jointly owned property, and the division of ownership is presumed to be 50%. Therefore, in the formula, my interest, the debtor's interest in the formula, should only be calculated at 50% of the entire value. And in this case, the court agreed with the debtor and accepted that argument. Okay. Now let's look at a second example, slightly different. In this method, the court agreed that 1/2 the value of the property was correct under this presumed joint tenancy ownership of 50-50. However, it disagreed with the fact that the debtor could use 100% of the value of the consensual liens against the property. Because in the court's view, allowing the debtor to do this, claim the full amount of the liens and half the value of the property, would result in a windfall to the debtor under the formula and unduly prejudice the judicial lien creditor. So at least in this case, the court said the application of the formula would require 1/2 of the amount of the consensual liens, 1/2 of the value of the property. Okay. And then let's look at this third approach, which is slightly different. In this case, the court said, yes, we must recognize that the debtor is jointly and severally liable on the note and owes 100% of it. So we will use 100% of the liens. However, I think in this particular case, it was a joint tenancy with the right of survivorship. And for the application of the formula, the court said, well, let's not use 50% of the value of the property. It could happen that the other spouse dies and this debtor becomes the 100% owner of the property, and using the full value of the property for purposes of the judicial lien avoidance formula is more equitable. Okay? And then let's look at the fourth approach, which is a little confusing. Rather than apply the formula as the other three courts have done by choosing one of those methods, the court did something completely different. It said, what is the value of the property, the whole value of the property? Let us subtract from that amount the entirety of the secured liens. That results in equity. What is the equity in the property? And because the property is co-owned, we will determine 1/2 of the amount of the equity, which is attributable to the joint tenant with the judgment lien debt. And from that amount, we will subtract the debtor's claim of exemption, which it appears based on the face of this that it is the actual exemption claimed by the debtor, not the hypothetical exemption that could be claimed. And that will result in non-exempt equity. And this non-exempt equity can be used to satisfy the judgment lien. So any amount of the judgment lien in excess of this non-exempt equity is avoidable, and the rest of the judicial lien remains in force and effect. The $24,688 of the judicial lien remains in force and effect after application of the circuit court's formula. So as you can see, these are four very diverse methods for applying the judicial lien avoidance formula. And what do we see in practice here in the Northern District of West Virginia? Well, we see the first example most often, I would say, usually because these motions are uncontested, and the judicial lien creditor must determine whether or not it's worth litigating the issue, especially for a small value judgment lien that apparently was not collectible before the bankruptcy petition was filed. So, what will be the rule in the Northern District of West Virginia once this case comes before the court? Here are 4 different options that the court could choose from.
We will now hear from Bankruptcy Law Clerk J.J. Voighthoffer about the fixing of a judicial lien.
In Section 522F, the Bankruptcy Code instructs that a debtor may avoid the fixing of a judicial lien. What does this term fixing mean, and under what circumstances might this requirement be an impediment to avoiding a judicial lien? In Ferry v. Sanderfoot, the United States Supreme Court attempted to address this issue. The court stated that unless the debtor had a property interest to which the lien attached at some point before the lien attached to that interest, he or she cannot avoid the fixing of the lien. In the specific context of the Ferry case, the Supreme Court denied the debtor's attempt to avoid a judicial lien held by the debtor's spouse on the ground that the lien arose out of a divorce decree, and that this judgment did not occur subsequent to the creation of an ownership interest in the property subject to the judicial lien. In other words, if the judicial lien was obtained before the debtor obtained the real property, the debtor cannot use Section 522F to avoid the judicial lien. However, this factual scenario has not been a deterrent for debtors filing motions to avoid judicial liens under Section 522F. For example, in the case of In re Anderson, found at 496 Bankruptcy Reporter 812, the judgment creditor recorded the judgment on June 22, 2010, and the judgment debtor purchased the property in October of that same year. Under the applicable state's after acquired property statute, the judgment lien attached to the real property. The bankruptcy court, however, distinguished Ferry as a domestic relations case and relied on a well-respected bankruptcy law treatise to allow the debtor to avoid the judicial lien under Section 522F, notwithstanding the fact that the judgment lien attached at the same moment that the debtor acquired the real property. Other courts have distinguished Ferry on the grounds that the debtor took title to the property and the lien at the same time, just as if someone had purchased an already encumbered estate from a third party. The citation for that is In re Perez, 391, Bankruptcy Reporter 190, and also on grounds that the domestic relations lien in Ferry was a consensual judgment lien as opposed to a non-consensual judgment lien. That can be found at In re Bear, case number 15-10452, found at 2015 Bankruptcy Lexus 3916. In analyzing Ferry, Collier on bankruptcy at section 522.11 calls the Supreme Court's reasoning flawed.
A motion to avoid a judicial lien under Section 522F of the Bankruptcy Code can only be filed after an individual has filed a bankruptcy petition. There is currently no statute or rule that governs when the motion to avoid the judicial lien is to be filed after a debtor files a bankruptcy petition. Sometimes, an individual debtor fails to avoid a judicial lien before the debtor's bankruptcy case is closed. Years later, when avoiding the judicial lien becomes important to the debtor, the old bankruptcy case may be reopened under Section 350B of the Bankruptcy Code in order to seek lien avoidance. This is exactly what happened in a Ninth Circuit Court of Appeals case named Culver LLC v. Kai Ming Chiu. There, the individual debtor filed a Chapter 7 bankruptcy in 1995 and 5 years later sold real property. At the time of the sale, the debtor realized that there was a $48,000 judicial lien encumbering the property. The Ninth Circuit stated that judicial liens are avoided retroactively to the time that the lien attached, the fixing of the lien. Because the debtor met the other requirements of 522F to avoid the creditor's lien, the debtor was able to keep the $48,000 in sale proceeds, notwithstanding the 5-year passage of time between filing bankruptcy and selling the property. Note, however, that establishing a legal right to judicial lien avoidance requires proving the existence of certain facts. If too much time has elapsed, a debtor may have difficulty establishing entitlement to relief. For example, in the case of Henry Horvath in the Northern District of Ohio, the creditor obtained its judicial lien in 2009 and the debtor filed bankruptcy in 2010. 10 years later, after the creditor had renewed its judgment in 2014 and 2019, the debtor reopened the bankruptcy case in order to avoid the creditor's judicial lien. In addition to berating counsel for failure to act at the time of the original bankruptcy case, the court noted that the judicial lien creditor was prejudiced by the passage of time. It had incurred costs in maintaining the lien and renewing it, and to appropriately respond to the debtor's tardy lien avoidance motion, it would have to incur additional expenses establishing the value of the property as it existed 10 years prior, and would also have difficulty establishing the value of the liens against the property. The undue passage of time, or lashes, was the basis for the denial of the debtor's lien avoidance motion.
Generally, even judgment liens securing non-dischargeable debts under Section 523A can be avoided under Section 522F. The exception to this are for domestic support obligations as described in Section 523A5. Relatedly, an issue exists regarding when exempt property can be liable for non-dischargeable debts also secured by judgment liens. In general, Section 522C1 provides that exempt property remains subject to domestic support obligations and tax debts. Exempt property is not subject to other types of non-dischargeable debts. And for a citation supporting that, see Harmon versus Pennsylvania National Insurance Company, case number 0922905 from the Western District of Pennsylvania, November of 2009. That court held the language of Section 522C2A unquestionably is convoluted. After untangling it, we understand it as effectively providing that if a debt secured by a judicial lien is avoidable in accordance with Section 522F, property which a debtor has taken an exemption in is not liable for the debt underlying the lien.